member of the public records you
Yes.
and sends that footage to the police,
Yes.
that's capable of prosecution.
It is, and the judge once told me the justice system's here to be a deterrent, not a benefit to the clients. I'm going to lose my job if I can't drive. She used the term, all hell will break loose. It's one go, and if you're going to lose your license, you might as well give it the full whack and try.
And try. Welcome to Britton and Times podcast, Is That Legal? I'm Paul Britton, a solicitor at Britton and Times Solicitors in London's Mayfair. I've been a solicitor for over a decade now, acting for clients up and down the country in some quite high-profile cases. And I'm joined today on this first episode by
Andreas Yanaki. I am a solicitor dealing with private crime and business regulatory issues. And I'm a solicitor in Britton and Times Mayfair office. And I've been a solicitor for 2 months, but I've been dealing with crime for over 5 years.
Great. So let's get straight into it, shall
Perfect.
we? Look, one of the most talked about areas of criminal law, and particularly criminal defence, are the road traffic offences. And what most people are frightened of is whether or not they'll get banned.
Yes.
How does that come about?
So simply, it's not the most glamorous offence in the world. It's not the ones that are reported in the news and all the high risk and loads of media attention. However, it comes about when you've essentially amassed 12 points on your license. You become banned. And that can be for a specific period of time, but it's case dependent and crime dependent. Now, it's quite an interesting area of law because you might not think you're a criminal, you're an everyday professional, but everyone knows someone who has got caught for speeding or someone who has run through a red light.
That's been a bit heavy on their foot and jumped that light, or done 33 in a 30. I mean, does it work like that?
Yeah, it does. There's bans of speeding, and I'm sure we'll speak about speeding in due time. But yeah, it ends like if you were speeding, you get 3 points to 9 points depending on what you were doing. It's dependent on how fast you were speeding, and if you accumulate 12 points at one time, you're banned essentially.
Okay, so when people say I was doing 33 in a 30, is that a thing?
There's this cult kind of mystery of whether these cameras have a plus 10% to leniency to everything, and it's not official. Some cameras may be wired that way, but I would always say to my clients, do not go on that as gospel. Also, some cameras may be calibrated that way, but you can also be caught speeding by a officer that has a gun, and they're normally pinpoints, and they're normally jobs worths that will fine you and prosecute you even if you are on 33 and a 30.
And they're the ones with the officer with a gun where you drive around a corner and
they're waiting.
You're speeding up out of the corner, and all of a sudden you can see someone. And someone did once say to me that if you've seen them, they've probably seen you and caught you.
Yeah.
By that point.
Exactly that sentiment. And with the new 20-mile-an-hour zones all around London, we're finding clients that are speeding more and more. And because they come down this road a year ago at 30 and they've been driving down this, we had a client where she'd grown up in the area. The road was always 30 miles an hour. She went away for 5 years to live in Spain, come back, drove the same route she's done for 40 odd years. Didn't realize it changed to 20. She was doing 29, so they hit her for going 9 miles over the speed limit.
How many times did she get caught before the first letter came through?
She got caught 3 times.
So was she looking at 9 points?
She was looking at cumulative 9 points.
And how many points do you have to get before you're disqualified?
12.
And is it an automatic disqualify at 12?
Depends, Paul. So there's a defence called exceptional hardship, and it's a defence where you've reached 12 points and you become what's called a totter.
A totter.
So it's not the word that it sounds like. And when I call my clients totters, they look at me as if I've offended them, but it's not. It's called totting. It comes from totting up points. So you've committed offences that have led you up to have 12 points. And what exceptional hardship is, it's a defence saying that you and an innocent third party will suffer exceptional hardship based on you losing your licence. Now, it is a very high bar to pass.
Right.
But examples can be, from a case I had, we had a young single mother, professional woman. She was a bit heavy on the foot many times, different times. accumulated 12 points, and she come to us and explained, I'm going to have difficulties with my job. I'm going to lose my job if I can't drive. I explained to her that the courts don't really care about the job, because a judge once told me that the justice system's here to be a deterrence, not a benefit to the clients. So it has to be exceptional. Everyone would suffer hardship getting to work, getting back from work from not having their car. But what was key in the conference that she told me, and why I specialize in this area, is she had 2 severely autistic children.
Right.
And she said to me, I take them to school every day. They're used to my car. They cannot feasibly get in a taxi. I wouldn't want my kids getting in a taxi with a stranger every day. And they cannot feasibly get public transport. They will have a meltdown due to their conditions, and it will be, she used the term, all hell will break loose. So I contacted her GP for the kids. We got medical records. We got a witness statement from the GP. And we went to the court and we mentioned the fact that she'd had issues with work as well, but we caveated it with the hard facts, that 2 innocent children who are suffering with autism would suffer exceptionally because of this. And she's still driving now.
So she had totted up. She was a totter.
Yeah.
She could have been disqualified.
Yes.
But the judge, the court, let her off, some would say, because there was a third party.
It's not let off per se. The points still remain there.
So she still got the points.
So she'll still have the 12 points, or if she was on 13, she was on 10, then got 5 points, she would still have 15.
Okay.
And every set of points stays on your license for 4 years.
So there you have it. You can drive around on a license with more than 12 points, and you have to mitigate, if you are guilty of that offence, by expressing to the court that there will be someone, or even yourself, that will suffer unreasonable hardship. So, I mean, that's great that we talk about that. And just wanted to look a little bit further into the threshold. So there is obviously the rumour that if you're doing 33 and a 30 or 77 and a 70, that you won't be caught or flashed by a camera.
It's not gospel. And I'd like to see the lawyer that has the guts to go to a judge and say, well, come on, judge, it was, but what about the 10% rule plus 2? It's not going to stand. So my advice to anyone watching is be aware of the speed limit, be aware of the cameras, and just don't speed.
Great. Okay, so moving on to our next area, driving without due care and attention. What does that even mean?
So cut down to simple terms, it's careless driving. So in legal terms, it's the driver's driving fell below the standards of a reasonable, competent driver. So essentially, that's a momentary slip. That can be a swerve in the lane. It can be going through a red light quickly. It can be, again, they can ladder it on with a speeding charge if they thought the speed you were doing was a bit excessive. And it's a momentary split second. So it's not anything reckless or dangerous. It's an everyday thing. So like I said, swerving a lane, not following traffic signs. I had a client before where a traffic officer was following him because he was in the fast lane of the motorway when all the other lanes were clear.
Right.
And the officer was flashing him. He didn't move over in time. So when they stopped him in the end, they done him for careless driving. Because
So is that so? Driving in the fast lane of the motorway when the other lanes are clear, that's not an offence in and of itself. Would that be an offence of driving without due care and attention?
If the officer, it's up to the prosecution and the police to prove it was, but if they're writing a statement basically saying we've warned him, the laws of the road, the highway code says this, and he's not doing it. I mean, the officer didn't seem like he was going to write him up and pull him over for that. He gave him at least 4 attempts to pull over, but after 4 attempts, it was not only the driving without due care attention but not going over to the lanes, it was also him ignoring the flashing from the officer. Obviously, he wasn't looking in his mirrors as well.
So there's more to it. There's lots of elements.
There's always more to it.
And someone that commits that sort of offence, what's the penalties? So
it's fines and points, and it's case by case dependent at all time, depending on how far we can mitigate it. There are defences to this. It's not a...
Yeah, what are the defences?
The defences are similar for every traffic offence, but for this one particularly, it's necessity. If there was an animal that just quickly jumped out on the road, I mean, we live in England, there's lots of wildlife that jump onto the road all the time. If there was, God forbid, someone that's collapsed in the road, you might have to swerve out the way. If there was a piece of glass that could have burst your tyre, you might have to swerve. I mean, because if you don't, you're going to go over it, your car will flip, and then it'll be even worse for the people behind you.
So circumstances play a big part.
Circumstances, and then that's breaks into necessity / medical reasons, because you might have a heart attack, let's say, or you might have a what's it called, a seizure, and you might need to move over, and you might cut a lane or go through a light or something, and that's what's caused. But that's always backed up with medical evidence and backed up with lawyers looking at it and putting it into a way where we can go to court and say, your worships, because it will be in the magistrate's court, your worships, this is the case, this is the reasons.
Okay, and so driving without due care and attention, dangerous driving, are they separate offences?
Completely separate offences, Paul.
Okay, how is dangerous driving any different to driving without due care and attention?
Dangerous driving is when the drivers, again, legal jargon coming along for our viewers, it's when the driver's driving falls far beyond the reasonable, competent driver and causes danger, basically.
So is it like a scale?
It's a scale, but it's up for them, the prosecution, to prove it. So if you're charged with that, you come to us, and we feel that it isn't dangerous driving and it's more driving without due care and attention or careless driving, we can present that as well because it's more serious. Dangerous driving can carry prison sentences.
And if as solicitors you prove that it's not dangerous, it's actually a lower offence of driving without due care and attention.
Yes.
Does your client does the case close, or do they reissue prosecutions with a different offence? What do they do?
So they could do that, but they also could just change it in court. It's very fast-paced in court. If they want to slow down, we mitigate. We also write representations to for our clients to the prosecution as well. So if I have a look at it and we're given the evidence before the case goes to court, if I look at it and he just swerved the lane, there's no one around, middle of the night, I don't think it's dangerous driving. It's careless. So we will write representations to the prosecution or the police and say, we believe that this is not what it is. We can tackle it and maybe try and get it thrown out first of all. But if you aim for the stars and just fall on the clouds, you're still doing well. So we'll write to get it thrown out. If they come back and say, well, it's careless, you just saved your clients a potential prison sentence or higher points.
So they downgrade the offence.
Yes.
You can't get off on a technicality that they brought the wrong offence then.
Well, there might be an element, but again, it's case by case dependent. It goes in with how they've stopped them. It goes in with all the little, the intricate legal things we do. Another thing is, again, we can fight it if there's a lack of evidence. If they've charged you with dangerous driving and we go to court a week before, I look at the file because that's when it gets released properly. We look at the file and there's no video evidence and it's just a statement of an officer saying that I thought he was driving dangerously. I'm sorry, officer, but that's not enough as evidence. When he gets cross-examined, he can't prove anything.
What would happen if you got to a final hearing? So you've had a plea hearing, you had some directions hearings, you got to a final hearing, a trial now, and some of the prosecution's witnesses didn't turn up for that final hearing. Let's say it was all down to an officer's evidence.
Yes.
What would happen if that officer didn't turn up to give oral evidence?
Then the prosecution really haven't got a case. They can apply to admit it as hearsay evidence, but we will rebuke that because everyone has a chance to cross-examine evidence. It's English law. It's an necessity.
And if you're successful,
that means it's thrown out completely.
Right. Okay. That's good.
So when I go to court and I see an officer's not there, there's a big smile on my face, and I inform my clients. And I always inform my clients, even if they've said to me they're worried, and sometimes they say I haven't done it, but I just want to get it over and done with. And I always say, don't plead guilty just because it's of convenience to you. We will fight this because most of the time officers haven't got the time to turn up. They get listed in months and they forget about it, or they don't turn up.
Before we continue this episode, we have a word from our sponsor. This episode of Is That Legal is proudly sponsored by Oliver Lauren Studio, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentations, and visual content that actually moves the needle. Check them out at oliverlaurenstudio.com. Design support just when you need it. So a much more recent offence would be the driving whilst using your mobile telephone.
Yes. Now,
there's been a lot about that since the offence came in, and it they're severely punished, aren't they? What do they
Yes.
get if they're caught?
6 points.
And I know there's campaigns now to say if you're caught using your phone whilst driving, it should be an instant ban.
There are people that petition for that, but what's important to know, and especially for the viewers, is a simple holding your phone or picking up your phone for a split second whilst driving is using your phone while driving.
And does it matter if you're using your sat nav on your phone?
Yes, if it's not docked, you can. That's why they're big on hands-free. And the police always say modern cars have CarPlay. Modern cars have that thing that you can, dock the phone in. So if you're using it as a sat nav, as long as you're not holding it and scrolling through it on your phone. We had a client once that was had his phone and he was and just driving and checking his texts and his updates. He was in slow moving traffic and he could have sworn to high heavens that he wasn't doing anything wrong. And I had to explain to him that no, you are technically driving your car and it was one of them vigilante cyclists. I'm not going to name names, but
Caught him.
That caught him, yes. And that's what's happening now. You've got these vigilantes going around as well as the police. And when you're caught on camera just scrolling through your phone in a vehicle that's moving, it's really hard to...
Well, that's an interesting point. So are you saying that if a member of the public records you on their phone, or dare I say, with their dash cam footage,
yes,
and sends that footage to the police,
yes,
that's capable of prosecution?
It is. And these people, they're not the most popular people, let's say, and they're prominent online. They use it for not only for justice purposes, but also for their social media platforms. They make their whole career on it. They go around trying to catch people. And
so they're profiting?
They're profiting, basically. They don't get anything from the prosecution element of it,
no,
but they get the likes and the attention online.
Who like that sort of footage of catching someone using their phone. But when you said if you have your phone docked,
yes,
so you have it in some sort of clip and you just touch it with your finger,
it's a grey area. I mean, again, this is an ever changing part of law. Because
I mean, would you say like if it's docked and you're typing a text message,
no,
that's using your phone.
Yeah.
If it's docked and the map's gone off and you hit like recenter my map, what would that?
I've not come across a case where an officer's caught that because, again, it's all dependent on video. So, again, an officer we had a case where our client was allegedly on his phone. The officer wrote a statement, but he was in a car coming out of a junction and our client was apparently talking on his phone, driving. The officer stopped him, said, you're on your phone. He rightly didn't say anything to the officer at the roadside. And we got the evidence back, and the officer didn't have his body cam on, so it's just his thing. And we said, how can you be sure that you saw our client? Our client was driving at 40 miles an hour. How did you know his hand wasn't up like that? How did you know? It's like, no, I definitely saw him. Don't tell me what you know. Tell me what you can prove. Is there evidence that my client was on the phone at the moment? And they tried to get call logs. Our client's phone didn't have the call logs that day. Must have been a technical malfunction. And we got him off. So it's not a definite in any case.
Okay, and so moving on to another road traffic offence.
Yes.
Driving without insurance.
Yes.
Now, some people say they thought they had insurance. Is that a defence?
Again, it depends. It's the favourite lawyer saying of it depends, because everything we do is on a case-by-case basis. We're seeing an increase of this offence because insurance premiums are going up so much. People can't afford to do it, as well as ULEZ, as well as buying new cars, as well as complying with petrol regulations and petrol, etc. That people are committing because they can't afford to have insurance. Now, it's a strict liability offence, which means you ought to have insurance. There's not really a set defence. No, I thought I had it. It's up to you to decide. That being said, there are a couple of ways where you can not get away with it, but the clearest one is if you reasonably believe you had it, you sent off to the AA or Aviva that you had the insurance. They hadn't updated their system. There was a system issue, an administrative issue per se. You can show payment. You can show a signed contract. That's a way of proving that you thought you were insured. The other one that we get a lot are from tradesmen that have company vehicles. If in your contracts you have a company car and it's explicitly said in the contract that the company is responsible for insuring the car and you can reasonably believe that the company should insure it if you've been driving it for 3 years. You sign the contract, they've insured it every single time. There's an argument the prosecution would say, well, you should know that, you should always know, blah, blah, blah. You should always check that you're insured. If you can fall back on a signed contract to say, my employer should have done it, he's always done it.
I mean, that's mad, isn't it? Like, you should make sure you're insured. I mean, what? How often? Every month? What am I supposed to do? Phone my insurance company every month and say, am I insured this month?
Yeah,
Who would do that?
Exactly. You fall back on if your company's offering you a car and you've signed the documents for it to be fully insured. It's the same with taxi drivers. Taxi drivers sometimes lease the cars from their taxi ranks. You see that less and less now with Uber, but that's what it was back in the day.
And I guess if they're leasing it,
yeah,
what you're saying, it's an all-inclusive price. So they'll pay, just to pick a figure, £1,000 a month, and that should include the insurance.
Yeah, it could be. It depends on the contract with the taxi rank. Normally, they're leasing it from the rank. The rank, it's a company car. It belongs to the rank. They're insuring it for them.
Okay.
And normally they do it in a way where it's not like a salary deduction, but they take it out their salary. It's a case in that sense as well. I've seen that as well. But again, if you could say, I get deducted £200 a month for my insurance, why isn't it insured? You potentially got a claim against your employer as well.
It's a good defence. And what would the punishment be for someone who is caught? I mean, you said it was a strict liability offence.
Yeah.
Let's just break this down into two parts. So let's deal with, what does strict liability mean?
It basically means a yes or no, like you should have it. It's not like a is it, could it kind of thing. It's you have to have insurance.
And if you don't,
you're going to get
the full whack of the law.
Full whack of the law. They throw the book at you unless you have these two very specific defences.
Okay, and then just to drill it down a little bit, so with that strict liability offence, is there an option to have an exceptional hardship defence?
It carries. It's weird because it does carry, driving that insurance, a mandatory ban. You can put exceptional hardship in, but it is possible. But it's about 6-month ban, so they take it very seriously. You can put the hardship in, and stay the ban or reduce it, because in the court and the magistrates, you have a way of speaking to the magistrates as well. It's case by case dependent. Again, you get either the magistrates are 3 people, 3 everyday professionals. They're not legally minded. They're everyday peers of you, basically. They're doctors, they're architects, they're accountants. And if you can say to them, I've got a kid, I've got fees, my job, etc., there's always a way of reducing things. But I can't for definite answer that, because that would be lying. I don't want to mislead the audience at all.
So anyone that's watching this,
Yes.
anyone that's watching this podcast, Is It Legal, that's sitting there saying, is it worth having a solicitor to defend me in court for one of the various road traffic offences that they could be facing, what would you say to them?
100% yes. When you go to court, you'll be amazed. And I say this to my clients that go to the police station as well. They think they can go in there and speak and it's an everyday occurrence. It's not. When you get in the court and you have the prosecution there, the court clerks, the judge, the magistrates, everyday people freeze. Lawyers are there because we've studied most of our life to get there. We do it day in, day out. We have the tricks, we have the knowledge and the advocacy skills to present your case and mitigate it in a way where it's more beneficial for you.
So it's being persuasive, and I guess your clients only get one go at it.
It's one go, and if you're going to lose your license, you might as well give it the full whack and try.
And if a client felt that they had been wrongly prosecuted, so they might want to appeal, what could they do? They
could come to us, if it's within the relevant timeframes. Come to us. We can look at the matter. Any good lawyer worth his salt will always write in a closing letter what their views on appealing the sentence is. We do it at Britton at time when we say we feel that this should be appealable. We don't think the matter was excessively sentenced. We think you don't have a chance of appeal, basically, in layman's terms. So we would obviously have a look at that. If he's coming to us for an appeal, or she's coming to us for an appeal, 99%, that means the current solicitors have said it's not appealable. again, we'll come to speak to you. We'll see the evidence. We'll request the evidence. We'll have a look at it, and we'll give you an honest breakdown. When we're not here to take clients' money. I know lawyers are looked at as these people that just want money, cash, 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 but it's not like that here. We will look at you and we'll give you an honest opinion of whether we think it's worth pursuing. And you're our clients. If you say to us, no, it's the principle, I want to do it, we'll happily defend you, but you will always get the most honest answer from us.
Right, Andreas, we've had a few questions coming in whilst we've been talking, and they build on what we've spoken about already. So the first one says that this person was recently pulled over by the police, and they said it was using their phone whilst driving. In actual fact, I was pulling my phone out of my pocket to dock it so I could use the map function whilst driving. I think this is extremely unfair and I want to fight this case. What I want to know is it worth fighting, and what defence I could have to use in the case?
Well, like I said when we spoke about it, simply using your phone and having your phone is an offence. So using it as a map docked isn't an offence. Having it in your pocket isn't an offence. But moving it from your pocket to the docking station isn't an offence. Now, we don't know the outcomes of this caller's case. We don't know what evidence is there. But I'd be happy if you want to call in and book a meeting. We can review the evidence of the officer, challenge any evidence if there's no video evidence, we can challenge that as well to prove it, and we can move forward. But we can't give clear and confidential advice without knowing all the elements of the case. But the crux is, if you were on your phone and you're caught using your phone by an officer, that's an offence.
Okay. Right, another one that ties in well with our speeding that's come in. It says, last week I was driving on the motorway doing 70 miles an hour, but I received a speeding ticket after I apparently did not adhere to the reduced speed limit of 60 miles an hour. I do not remember seeing any signs for the reduction of the speed limit. I want to appeal this, but what is the best way to bring about my defence, if any?
So it wouldn't be appealing because I guess it hasn't gone to the court yet. It'd be defending it. I think that's what the caller means. Now, I'm guessing he means when you drive on the motorway and they reduce it for traffic stagnations, there's a sign. We all see them. We all hate them when we're driving on the motorway where you're going 70 and it says 40, then 30, then 20. There are laws and regulations that these have to be clearly displayed. They're normally on them signs over the bridges or the structures over the motorway. And there are very integral parts of the highway code and other legislation stating what kind of font has to be used, what kind of size has to be used, and these differ from county to county. So I'd be interested if you could book an appointment so we can have a look where you live, look at the rules and regulations for that county, see where they stopped you, see the evidence. We've had cases before where up in Staffordshire, they had a similar case, and the writing they'd put on the board wasn't the right font or illuminated enough. And on that technicality, we got the case thrown out.
Good. All right. Another one. Right. This one's a bit different because they admit they were speeding. It says, yesterday I was caught speeding. Admittedly, I was speeding, but only due to circumstances. My wife had told me to get home as fast as I could as she has a long-term illness and she said she needed urgent help. I currently have 9 points on my license, and this ticket would bring me up to 12, which puts me at risk of losing my license. I know that I was speeding, but it was an emergency. Again, it says, can I appeal these points?
So he's admitted it to us, and as lawyers, we know we can't lie to the courts. We're officers of the court. If the clients come to us and said, I've done the offence, we can't lie to the courts. However, it sounds like he's going to lose his license. He's going to become a totter. And for that, there might be an element of exceptional hardship. And in that, it is his wife that has a long-term illness. Depending on what it is, if he's the sole carer for her, if it's life-threatening, the illness, if she was passing out, if she suffers from seizures, let's say, or she blacks out, or we don't know, we're speculating here. If there's a ground that he was rushing there because of a medical emergency, there's a high chance that we can get this on an unreasonable, exceptional hardship basis. It ties in with the case we recently done, Paul, where we had that gentleman that was speeding home doing 90 and a 70 because his wife, who had previously suffered a miscarriage, had postnatal depression, was carrying his child, a different child, and she was having contractions and pain. And because he was so scared, and because of the complexities of the birth before the complications, he was speeding home. We mitigated the magistrates, said he's doing what anyone would want their husband or partner to do and be there for their wife. And we got him off. So again, please book in a consultation. I'd be happy to look through that.
Well, carrying on with that thing, we've got another question that has come in, quite an interesting one. This one is coming from a surgeon at a public hospital. They say they operate on multiple patients every day, saving lives and helping everyone they can. Unfortunately, the other day, I ran a red light by accident, and even worse, my license has already got 12 points. I am in the middle of nowhere, and there is no public transport routes that come anywhere near me. An Uber or a taxi would be increasingly expensive, and I cannot afford it on my wages. What are my options?
That's a good question. A lot to break down in that.
There's a lot in there. So, surgeon, hospital, 12 points.
So, going back on that, it's she obviously, or he or she, we don't know, has an important job. She's saving lives, and doctors are the backbone of our community. What would we do without them? If this doesn't sound like an exceptional hardship application, I don't know what does, Paul. Because why should innocent people who are in medical need suffer because she's going to lose her license? Also, she's admitted that there is an option of public transport, but based on where she lives, there's an issue on that. Again, if you want to book in a consultation, we'll look at the map, we'll look at the local bus routes, we'll look at stuff like that. I admit as a surgeon, if you're going to be called out at 1 a.m. in the morning, you don't want to have to wait for the next bus. And
I mean, surely it couldn't be in the public interest.
It's not in the public interest whatsoever
to disqualify one of our surgeons, a doctor.
We had a case once where we had a specialist. I can't remember the title of her profession, but it was someone who dealt with complexities during birth, and she was on call 3 or 4 times a month. And she's one of the specialists in the area in London, and she was losing her license. And we did an exceptional hardship application saying exactly that. If she's called out at 1 o'clock or 2 o'clock in the morning, or even 4, if she hasn't got a car, she doesn't want to be waiting for an Uber. She doesn't want to be waiting for a bus. And she lived, again, similarly somewhere where it's not like we take it for granted in London where buses come every 10 minutes, but in places like up in the north, up in Ipswich, then they're not every 10-minute occurrences. So we presented at the magistrates and said, why should innocent people, a baby's life could be risked as well as the mother. So because of her job and how important it is not in the public interest to do this. And again, we got her, she's still driving.
Good, right. This is an interesting one. Yesterday, I received a letter in the post claiming that I have been sentenced for speeding. The problem is I wasn't notified of the offence or even the court date. Obviously, I want to appeal this as it makes no sense to me, but what are the first steps here?
This happens more often than you think. Essentially, there's been an administrative error here. The court may have sent the documents to the wrong house. That being said, if it's a driving offence, it's basically probably on speeding or an offence that we've mentioned prior. It's up to the driver to make sure all details are correct. So your housing matches your what the DVLA have for you, etc. If that's all correct, and you can say that I live here, my license address matches my current address, I've never received post of this nature, you can then do a statutory declaration, which is a solemn promise to the court in witness of a lawyer or another professional or a magistrate's court can get one as well. And basically, you say the standard procedure is, I've lived at this property for X amount of time. Hopefully it's the time of during where these offences have happened. I haven't received any post. There's been no postal delay. I've received all my other posts normally. I've not been on holiday for longer than X amount of time. I've received all my other posts. I believe there's been an error here where I haven't been notified. Get that signed off. Come to us. We will then send that to the magistrate's court, explain that there's been an issue, and reopen the case.
Well, there you have it. That concludes our first episode of Is That Legal? There is a comment section below. If you have any comments or questions that you would like to leave, then we welcome those and we'll try to get round to answering just as many of them as we possibly can. If you've enjoyed this first episode, it'd be great if you could give us the thumbs up and like, and even better, if you want to see what's coming in the future, then subscribe. That's me, Paul Britton from Britton & Time Solicitors, joined today by
Andreas Yanaki from Britton & Time Solicitors.
For contact details, you can look at our website, www.brittontime.com, or email us at info@brittontime.com. Thank you for listening.